now, there are two active Constitution Amendment Bill. One is 129th, another is 130th. So we have total 32 governments and we have their 32 Council of Ministers. 130th Constitution Amendment Bill is one, but apart from these, apart from this one, two other bills are also introduced. That executive action without judicial oversight, because in this mechanism there is no judicial oversight. Principle of natural justice talk about the free and fair trial. Now, as a student of polity, what should be our point of view with respect to this very controversial topic? Hello aspirants, my name is Himanshu Kishore. Today we are going to discuss a topic which has created huge controversy last year when it was introduced in the month of August. It is 130th Constitution Amendment Bill 2025. When it was introduced, it basically divided the opinion very radically and sharply. There are proponents of the bill basically say that this is a very landmark initiative to clean the politics, while the opponent of this initiative basically say that this is a potential political weapon in the hand of government to settle score with the opposition political parties. Now, before we make our final opinion, let's first look at the details. Before I get into the details of the bill, I want to clear a very something factual confusion here, that some of you might have seen that our constitution has so far been amended only 106 times. The latest amendment that was done through this 106th Constitution Amendment Act 2023. After that, suddenly we have this 130th Constitution Amendment Bill. So the reason behind the gap in numbering is that there have been certain initiative when Constitution Amendment Bill was introduced, but it could not be passed. Okay, right now there are two active Constitution Amendment Bill. One is 129th, another is 130th. 29th is related to one nation, one election, and this is related to basically the automatic removal of ministers in the government. So let's start with the details of the bill. This bill basically proposes the automatic removal of a minister in case of certain conditions are met. So minister basically means any member of the Council of Ministers. It includes Prime Minister, Chief Ministers, Senior Ministers, Cabinet Ministers, Junior, Deputy Minister, all sort of ministers. Basically, a group of them is referred as Council of Ministers. And this Council of Ministers is found in India at union level, at state level, and in union territories with legislative assembly. So basically one can say that there are one union, 28 states, and 3 UT government where we have a state legislative assembly, Puducherry, Delhi, and Jammu and Kashmir. So we have total 32 governments and we have their 32 Council of Ministers. So this bill and its proposal basically is applicable on all the ministers. It is not meant for MPs or MLAs. Let's be very clear about it. Now, currently for ministers, the provisions are that ministers remain in office at the pleasure of President and Governor. And in order to become a minister, the only criteria which is there is that individual has to be member of parliament or member of legislative assembly. Apart from that, there is no separate disqualification criteria for someone to become a minister. Now, because ministers remain in office at the pleasure of president and the individuals are recommended by PM and CM for ministership, so basically there is no fixed tenure for a minister, and minister basically can be removed by president and governor on the recommendation of prime minister and chief minister at any point. All right, so this has been so far the provision with respect to the ministers. Now this bill proposes that if any minister is arrested and detained for 30 consecutive days for a serious crime basically mean that any crime for which the imprisonment or the punishment is more than 5 years of imprisonment. So that is a serious crime by any law enforcement agency. So it has not been clarified ki Union Government Enforcement Agency or ED or CBI or NIA or State Police Force, any means any law enforcement agency, if they can arrest and detain a minister for a serious crime for 30 consecutive days, then the minister will be removed from his or her office in an automatic manner. There will not be a need of resignation. There will not be a need of removal order from government or from governor or president. This bill basically proposes automatic removal. Now, before we get into the analysis of these features, means how justified and reasonable these features are, let me tell you something factually important, particularly from prelims point of view, that this mechanism for automatic removal of minister is for this basically 3 bills are introduced. 130th Constitution Amendment Bill is one, but apart from these, 2 bills are, apart from this one, 2 other bills are also introduced. Why? Basically for obvious reason that in Constitution, we have provision with respect to Council of Minister at Union, State, as well as in Delhi. For these these 3 type of Council of Minister, we have provision in the Constitution, but for Puducherry and for Jammu and Kashmir, 2 separate bills. Basically, there are 2 different laws, and in order to bring amendment in those 2 laws, we have introduced these 2 bills. Okay, so these are collection of 3 bills to bring that automatic removal mechanism. All right, now let's get into the debate, basically the argument of the supporters and the people who are opposing it. So government's point of view is that in recent few months, in fact years, we have seen certain instances where the governments are being run from the jail, because either the chief minister or some senior minister is in jail and they are running government from there. The senior bureaucrats are going to jail to seek orders and advices from these ministers. And they say that this basically does not look good. It brings down the public trust in the government. So basically they want to make sure that governments are not run from jail. That is the point of view of Union government who have brought in this proposal. Now, what is the point of view of opposition? Opposition says that this mechanism has a potential to be abused as a political weapon. They say that executive action without judicial oversight, because in this mechanism there is no judicial oversight, charges are not being framed. Here it should be very clear that in criminal justice system there are 3 stages. One is pre-trial, then trial, and then post-trial. So in pre-trial also there is first FIR, and after FIR there will be a charge sheet. Charge sheet is framed only when police has some serious evidence and basis to go ahead with a case against that accused. But in this mechanism, it is not said that when charge sheet is filed, charge sheet की बात नहीं हो रही है, and charge sheet is framed not just by executive, rather charge sheet is framed by police under the guidance of a judicial officer. So even if we reach up to the charge sheet level, there will be some scope of judicial oversight, but that is not the case. Executive basically under certain dedicated preventive detention law can get, I mean, it is feasible that the executive can detain someone for 30 consecutive days, and that too without judicial oversight. So they are saying like this can be used to topple the government. They also say that this is a violation of the principle of natural justice. Principle of natural justice talk about the free and fair trial. Trial means in that the accused should be given a chance to produce his or her side of the story in front of a neutral, independent, unbiased judiciary. And the third thing is that in our legal framework, this principle that everyone is innocent until proven guilty is a very, like, it is the heart of our legal system. So this principle is also being violated, because like when you remove someone from office, in a way that is a kind of punishment, because it takes a lot of effort and to convince many people to win over the trust of many powerful people, then only someone can become a minister or chief minister. But then they lose that authority, they lose that access to the powerful institution because of this automatic removal mechanism. These were the point of view provided by the government as well as the opposition side. Now, before, as a student of polity, we frame our opinion about this very controversial topic, I would like to show you data with respect to the extent of criminalization in our parliament. In our parliament, the data we have from 2004 till 2024, we can clearly see that currently almost half of the MPs who are in this latest Lok Sabha are having a criminal background. And the MPs with serious criminal background are also not that far behind. They are more than 40% in our Lok Sabha. All right. So this mechanism, this 130th Constitution Amendment Bill, the mechanism of automatic removal which it is proposing, the ultimate goal is to bring down the extent of criminals and the criminalization of politicians who are there, either part of parliament or executive. That is the goal. But for that, there have been multiple suggestions from judiciary, from Election Commission of India, and we should implement those initiatives first if we are really sincere with respect to the criminalization of politics and if we really want to bring it down. Now, I would like to highlight here this particular case, Manoj Narula case 2014. In this particular case, Supreme Court highlighted or in a way presented this doctrine of constitutional trust. Supreme Court said that Prime Minister and Chief Ministers are having this absolute discretion with respect to the selection of a minister. It is a complete discretion of Prime Minister and Chief Minister to pick anyone as a minister in their cabinet or in their council of minister. And nobody can question, and no, there is no criteria, there is no condition that is basically upon them. Hence, when they are given this absolute freedom, absolute power, with this power, there is also a constitutional trust. Means Constitution trusts Prime Minister and Chief Ministers to pick that sort of individuals as their minister who are not having some criminal background and who basically enjoy certain trust in the eyes and minds of the people. So Supreme Court as such did not put any condition, but they reminded this constitutional trust to Prime Minister and Chief Ministers with respect to their selection of ministers. After this, in 2016, Election Commission of India basically made a recommendation to the Parliament. Election Commission of India said that if we have any candidate against whom there are charges framed under a serious crime, and serious crime, again, the same thing, that the crime for which punishment is more than 5 years of imprisonment. So Election Commission of India said that we must bar all the candidates against whom the charges are framed. Now here, understand, charges are framed does not mean the person is convicted or the person is proven guilty. But framing of charges in itself include the judiciary as well as the executive to a certain extent. Hence, if the things have reached to that level, framing of charge sheet, then that is something serious. So Election Commission of India basically recommended in this sense. Apart from this, after that in 2018, basically a PIL was filed by Public Interest Foundation, and here Supreme Court said to Parliament that we should not allow tickets to be given to candidates against whom serious criminal charges are pending in the court. So one thing is clear, that as it happened in the Lily Thomas case, that Supreme Court said that if you are convicted in a case where the punishment is 2 or more than 2 years, then you basically lose your membership. So there in Lily Thomas case, it was contingent upon the conviction. But when it comes to these proposals, in these proposals, basically the charge sheet is highlighted. So it shows the level of the low level of tolerance basically towards the criminalization of politics. And these proposals, these recommendations are already out there, and we need to act upon these. So what should be our ultimate opinion? Our ultimate opinion should be on these lines, that prevention is better than the cure. we must stop these individuals from entering into the parliament, rather than we first allow them to enter into the parliament, and then after that, once they are made minister, we are removing them. Okay, if you are a minister and you are having these criminal background, and we are basically, because only those people who are having certain criminal cases going against them will be put in the jail, right? So if we really do not want government to be run by the or from the jail, then we should also ensure that in our parliament, people with serious criminal charges filed against them must not be sitting. So that was my take on this very controversial issue with respect to 130th Constitution Amendment Bill. So here I leave you with this information. We can always use these cases and these recommendations in our mains answer writing. And with respect to the prelims, I will say that Lily Thomas case, the Section 8 of Representation of People's Act, and particularly these articles of the Constitution which are basically related to this proposal, these things can be of importance. Thank you very much. Wish you all the very best.